Hi students, I welcome all of you all to the second day of the marathon for drafting. Now, in last lecture, that is in the yesterday, what we had done in the part 1, I had taken you all through some drafts for code formats, for agreements, deeds, and in today's lecture, I will be taking you all through each and every chapter, tell you all what is the important drafts, and also take you through some important drafts which I have not done yesterday. Good. So before I start, can I have GTG in the chat box? And just one request, please like the video and share it with your friends. That is the thing that I can ask from you. That's all. Right? So please do that, and we are all set. Just okay. Let's begin. Okay. Dave, great. What about others? Let me know. So I'm going to teach you all some practical stuff as well in today's session, like how I done yesterday. And one of this is something which you have not even seen it in your particular, in your own module also. I'm going to teach you something more than module as well. Okay. So GTG in the chat box, everybody, and I'm going to show you all some very important drafts and everything that you need to know. Let's start. So Dev is ready. What about others? We need you all to be ready. After this, drafting will be extremely simple and scoring for you all. Okay, so just waiting for you all to give a GTG, hit the like button, share it with your friends as well. Okay, thank you so much for the love that you have shown. Please don't forget to inform your friends that such classes also exist, because many students are struggling to find mentors to help them, and I am here. So let's begin. Hi. So we had started the drafting marathon, and in the part 1, I had taken you all through all the important drafts which used to cover approximately 95% of the drafts that come in your examination. In today's, I will be showing you few more drafts which I have not covered yesterday but are equally important. Okay. Now for the draft is one is of a legal notice. So once you become a lawyer, drafting legal notices are very important. You send, what is a legal notice? It is basically a intimation to the other side that if you do not do XYZ, we will take action in court. Legal notice. Not only that, but how to even reply to legal notices. How to reply to legal notice, what is the format for that? Second, what we will be learning, certain letters how to write. Okay, sometimes letter writing. So what do you mean by letter writing? In the exam in the past, they have also told that write a letter to the bank manager. Okay, in drafting only they've asked, write a letter to the bank manager telling X, Y, Z. Now, how do you draft? What is the format to write letters? That also I will be telling you in this lecture, as it is very important. The third important thing I will be telling you is certain about notices and like a public notice. So just for example, if you would know that a company, a corporate, when they have to issue a notice of the meeting, they also say that they will publish in a newspaper, English, regional and local level newspaper. So how that notice of newspaper advertisement will be made? So I am just going to do for one of my client also. Okay, it is basically transfer of a flat, and for transferring the flat we have to give a public notice in 2 newspapers, because it is a transfer to a person other than the nominee. So you don't need to know, but I'm telling you practically what we are doing. So learning how do you draft a public notice is also there, and it is there in your examination. Next, it comes in your examination also. The fourth one, another important thing is, I think I've covered most of them. Note, very, very important with respect to resolutions. Okay, how to draft resolution. Now, as a company secretary, drafting resolution is mandatory. Okay, you will definitely do when you have a drafting for a board meeting, or it is a general body meeting. Drafting of resolution is there, very, very important. So all these things are equally important, as I have taught you all something yesterday. After this, we will be going and we'll be covering each of it chapter wise. And in this chapter, this is there, and everything will be complete. So what is the plan for today's lecture? Understand one thing, that the drafts in examination come for around 40 marks. Drafts come for around 40 marks. The rest 60 marks is pure theory, which I believe you can already crack it by yourself. Okay. In my marathon, I'm going to make you a master in the draft aspect. Get this 40 marks where people lose the 40 marks. Right? So let's begin. Now we'll be starting and I will be taking you through. So I'm not teaching you a particular chapter. I am just focusing on the draft. So when we go through each lesson, we will see which drafts were asked, and the important ones I will take you. Good to go, yes or no? And sir, I'll also give you one hint, or one tip with respect to theory aspect. Okay. So in theory, you have to know, obviously very basic theory is there, but the answer has to be very highly worded. For example, if I ask you the meaning of the term document, now everyone writes general stuff, but very few students will write the section numbers. So remember, even with respect to theory, you need to quote the section number. Okay, at least you can only quote when you learn at the time of studying. And you need to quote the case laws given in the particular module. Okay, and then the theory part you can build by your own words, keywords, etc. But this is what I expect. So what is a document as per section 3 subsection 18 of the General Clauses Act? Okay, all of that you need to know, right? And that is how you will start and explain. So this is just a tip with respect to the theory, which is not the part that I am teaching today. So I am going to cover the drafts for you. Now again, while going through this, I will also tell you the important pointers which I come across. In this chapter also, if you go to see deed, okay. Now what is a deed? Very, very important. Now many students, when in the exam they're asking, so this I'm just telling you, it's a theory aspect, right? The theory part, I'll tell you what mistake students do. When they ask that write a definition of deed, okay, or this is the following type of deed, a latent deed. What is a latent deed? It's the exam question. What is a incomplete deed? Okay, so what is cyrographism? These are words, types of deeds. What is indenture? These are types of deed. Okay, now before even getting into that, when I ask you the meaning of the term deed, you obviously will write a deed is something, but you always have to quote the author. So you will write that the most suitable and comprehensive definition has been given by Norton on deeds is as follows: that a deed is a paper, it is a volume is basically wall, and parchment is an animal skin. Okay, and it has to be signed, sealed, delivered, where the rights of the parties have been transferred. Okay, so you write this. So see, the level of the writing has to be a little higher, and this is what will help you get a exemption. So I'm just teaching you theory, what is important, how it is to be written, and normally what you miss out. And then obviously we have the types of deeds which are equally important. Then directly coming to the drafts aspect which we plan to do. Obviously this aspect is also important. What is the difference between a deed, agreement and contract. A deed, agreement, contract, and then later they come conveyance. Okay. So if I ask you, what is a deed? Sir, a deed as per Norton is a instrument in which it needs to be signed, sealed, delivered. It's a passion, volume, includes all of that. So those you need to write. What is an agreement? Now if you see, an agreement is all the promises made. Okay, it forms a part of the agreement. So every promise made for consideration to each other is an agreement. And what is a contract? An agreement enforceable by law. Now at least we know what is an agreement enforceable by law, but writing the definition to H, okay, it's given, we'll see when we come to it, to H here, to H. Okay, now many students will write an agreement is a contract is an agreement enforceable by law. Now you know that you are writing contracts, it is everything, but will you quote the section? So learning the section is equally important. So I'm telling you, your section, what is an agreement? It is under section 2E. So learn it in order, so you will be able to mention and write it. This I'm explaining just how the theory needs to be pepped up, dressed up, etc. Okay. Now, as we go forward into the first part, then comes a little bit of drafting aspect, but then they ask what is a circular. The circular is normally to disseminate information. It is circulate some information for a specific reason, right? A circular is to circulate information. Now it could be basically that tomorrow is a holiday, or tomorrow we are having Rose Day, the HR will send a circular among its employees. Or I can give a circular to my customer that a new product has been launched, or to my supplier that I need XYZ. Okay, so a circular, there is no legal definition that we are following, so you're free to write whatever you want, just general stuff. Okay, now how a circular is to be written, now I'm teaching you drafts which I have not done yesterday, and we'll go through each and every chapter and knock off the drafts. Okay, done. And while doing that, the important theory, when I come, I will tell you that this is very important theory, please do it, and when you're doing that, I'll tell you what you normally students miss out. Okay, next, draft circular. Okay, now it is drafted in letter format. I told you I'm going to teach you how to write a letter also. So here comes a letter format. Okay, how to draft a letter to the manager, to the bank, a company sending a circular will also be in letter format. Okay, so this is what I have told you. Let's see. So I'm asking you, a letter format, your company is sending out a letter, could be to disseminate information, that's a circular, to its people. So what all will you do? How will you present it? How will you present it? Very important. Now this is the today's first draft that I'm teaching you. Okay, how will you do? So the very first one is, pay attention. Okay, circular. The circular will contain the any particular company. When you see, they will have the letterhead. You know, this part is already printed. This part is already printed. It is a letterhead where the Reliance Industries having the CIN number, your particular website details, phone number, all those things. So the letterhead will be there. You will have all those information. Concept clear? This is the part of the letterhead. Second, now the letterhead I told you is a letter format. So let's finish that first. So always a letter has to have a date. A letter has to have a date. If date is not mentioned, your letter has zero value. It's just like you've not signed a document, it's going to have zero value. You might not clear the exam only, not get the marks. So always start with the date. Then it's a to. So always a letter is sent to someone. Okay. So if it is on my letterhead, they know from whom it is, right? So letter format we are doing. So two. Now you will give to the relevant employee, to whoever it is, etc. Then, so first comes the date, then comes the to whom you are sending their reference, whether you're sending it to an authority, to an employee, to the stakeholders. Okay. Then third, you will start with subject, what it is for, circular for XYZ, or it is a letter for anything, okay, or dividend distribution, warrant letter, etc., anything. And fourth, then you will write sir or madam. Normally people interchange it sir and madam above, and then they write subject below, then again they lose the mark. So it's legal principles need to be followed. Sir, madam, you draft and complete. Then you give that for any queries, please contact me at so and so numbers. Yours faithfully, a signature, name. So basically, who are you and your designation. Every company will send a letter through its employees. So who is that? Who? What is his designation? What is his contact number? Concept clear? And then now coming to the circular point, you just write the circular number. Okay, again very important, because multiple circulars are there, so circular number will help you have a reference when you get a reply, maybe. So then at least they will say with respect to circular number 219, you have to leave it blank. So do I have to assume facts or do I have to write blank? Okay, now let me take you through one important thing. If you see this, what is this? These are past exam questions. These are all this I have given to everyone in our website. Okay. Now see, in the exam, this is the model answer by ICSI. This is the deed of so and so made on dash dash dash, like this. They don't assume the facts. So you have to keep it blank. Okay. If you see the other formats also, they leave it blank. Okay. So they leave it blank. So similarly, you also can have to leave it blank. This is a model answer by ICSI. Open your guideline answers, you will get this, right? Okay. Now, so this is what we are just seeing, that what it is there. Now I told you even resolutions they have asked in the exam, so that I will take you through when I come to it. Clear? So I hope I made myself clear. This is there. Now, this is another kind of a circular number dated to subject clarification of holding a AGM through online services, sir, madam. So basically this was a letter given to a particular letter given by the company to the authority that we are conducting a online AGM. So that is there. Then comes, okay, public notice. Now a circular is always to specific people, whereas a notice is given to the public at large. Sir, what does it mean? Circular is always, remember, employees you give a circular, suppliers you give you a circular to disseminate information. Whereas when it comes to notice, public notice is given to public at large. So we have read so many times in company law that a notice needs to be published. A notice needs to be published in the newspapers that you're holding a meeting. So now they will tell you to draft the notice. They have not asked till now ever draft a notice, but according to me they can ask you. Okay, because final level, don't just go on past paper what they have asked, that only they can always ask. So these drafts which I am doing today are not asked that much, but according to me they complete that part of drafting, that this also you need to know, so you will be able to do it. So will we be doing public notice? Definitely yes. Now again, beautifully I have told you everything, that a public notice is also in letter format. A public notice, okay, a public notice will also be in letter format. So letter format, I told you, it always starts with a date. Okay, in that, before coming to the date also, what do we start? you write this. What is this, sir? Can anyone tell me what is this? It is called as a letterhead. So name of the organization, their registered number, their SIN number, email and website. So this, if you're not mentioning, you're starting at a very bad footing, right? This needs to be beautifully presented. And this is exactly how you will present. Then below that, you will see a public notice. Public notice is a reference, like how you write the word circular. So here you will write the word public notice, and then you start with date. Okay, you can write now. Obviously, a circular is given to certain people, so we have to mention it. But if I'm giving it to everyone, then I don't need to mention to whom I'm giving. It is understood. It's a public notice, right? So dated, subject. Then you will say this public notice is issued by so and so company to inform the company about. Done. So this public notice, this is how you start. This public notice is issued by so and so to the public, informing about, or to inform the public about the notice of the meeting, etc., details. Okay, the financial disclosure, policy change, whatever it is. Okay, sometimes what happens, if there is a name change, public notice is needed. Details of this notice, you will give that this notice is issued in accordance. Now in a notice, further, always a notice sometimes might be a statutory requirement as per law. Mention that law, that this notice has been issued under Companies Act section 73 to 76 for deposits, and that is why we are doing. And the purpose, so always refer the section in the notice, that why are you doing this public notice. That second, what is the purpose? The purpose of the notice is to whatever update the stakeholders about XYZ change taken, or management change, etc. And if the instruction mentioned shall notice shall applicable from so and so date. So if there is an applicability of this notice, they will do that. The notice is issued in compliance with so and so law for any queries. Now this is always that you can write, so write it very well. For any questions, clarification, additional information regarding this notice, please contact so and so department, phone number, then your designation, who is doing it, and the organization, and sign. Clear till here? So this is a public notice. Okay, and that is it. Think the letter of credit. The theory of this is extremely important. Okay, obviously others are also important. When I see something extremely important, I will tell. Okay, this is a theory, not a part of today's lecture. Today's lecture is about draft and giving you importance for theory. Okay, so this is super important, very important. Letter of credit and bank guarantee, and this is exactly what has come in the exam repeatedly. You can see the past exam question, you will come to know. Not only that, the types of letter of credit. Now sir, what is a letter of credit in short? You can tell me. So letter of credit is basically a international document, okay, as an international guarantee that is given. So a documentary credit, a bank issued financial document that guarantees payments to the exporters in terms of the LC. So if someone is supplying me goods from another country, why should they trust me that after I receive the goods, I will pay them? I might just import the goods and not pay them. They will find it so difficult to come in my country and fight with me. So that doesn't work in international trade. So always letter of credit is used in international trade. Sellers from abroad do not sell the goods unless they get a LC. So then I will tell them, don't worry, you give the goods, bank is giving guarantee. So it is a bank guarantee only, but in international trade, and the methodology, the flow is a little different. Okay. So very important, the types of LCs, etc. Okay. Documents, etc. This is not getting into the theory aspect, but you need to know one of the most important things. Now, coming to mostly, obviously, a bank guarantee. If a seller is asking, they would want an irrevocable bank guarantee. The bank can nobody can back out. If they are sending me the goods and they are expecting a guarantee from the bank, they would don't want the bank to back out, right? So a irrevocable power of attorney. Okay, very very important. Now again, this if you see, it is in which format? Agreement format or court format or a letter format? Quickly tell me everyone. Look at it and tell me. Okay, very good. So this will be in letter format. It will be in, see, all these other side drafts which I'm telling you, the internal contents you write it as for facts of case. I'm telling you the legal structure, the draft structure, how it needs to be done. Clear? Letter format. Very good. So there are the great. So date, to, subject, and dear sir and madam. Perfect. And then you write at the request of so and so, we, the issuing bank, issue the irrevocable letter of credit. So you need to know who is issuing the bank guarantee. So it is the bank that will give the guarantee to the seller on application received by the seller. So key terms, etc., all this will be given and then you sign. Now obviously a letter of credit is always issued by the bank. So you will write in the signatories bank name, sign, etc. Concept clear? Now, bank guarantees also similar lines, just it could be in domestic trade. Okay, very important, all these points, bylaws. And that's it. We are done with the chapter. In lesson number 2, I have already covered the entire theory aspect of it, of the what is a deed, agreement, etc. It doesn't have any drafts. Now, when we come to this chapter, again, I don't think this has any. So, this also has theory about all the laws. A few acts overview is there. They don't have any drafts. The real drafting starts from lesson number 4. The real drafting starts from lesson number 4. Clear? So now we are going to see the drafting aspect of each chapter. The chapter doesn't have, we'll skip the chapter. Okay, how to draft a document, we've done all this, the main, all this. Now someone will say, sir, can you give me importance? My friend, if you want importance and then you will be able to draft, really you have not understood the purpose. You are not fit to be a professional. You will only be a professional when you say that anything you bring, I will draft. So acquisition, okay, fine. The format will remain the same. We have done the format. Okay, this acquisition agreement made on so and so date at so and so place between party 1 of the first part, party 2 of the first part, whereas party 1 has approached party 2 to do so and whereas the party 2 has agreed on the terms and condition mentioned below. Now this deed witnesses as follows. Write the perspective first with consideration clause, the other acquisition agreement, whichever it is. Then you write in witness whereof the parties hereby have set their hands on the dates mentioned herein, and your agree, sign, seal, deliver concept over any of this agreement you should be able to draft, right? And obviously you don't have to sit and think what clause I will write. There are some standard clauses in everything: covenant, indemnity, your consideration clause, your arbitration clause, your termination clause. So these are all the clauses which are common. Confidentiality clause, non-compete clause. Make the clauses already. I have already given it to you all. Make that clause and your job is done. Just copy paste it, right? So this is done. So all these draft parts are done. Very very important. I told you all, drafting of power of attorney, extremely important. It is one of their favorite questions, because when you start a power of attorney now, they always start to whom, to all know. So they all start with to all men, know it. So there is a start. See, or you can start with this power of attorney, but very important, look at this. By this power of attorney, or to all these present shall come. So just learn the one draft and finish that. And always power of attorney is an I. It's mostly because I'm giving a power, na? And few points that to whom you're giving, all his acts are yours. Then what all power are you giving? Any restrictions are there? And you will end it. Okay. So this we had done yesterday. Power of attorney. Now there is no right or wrong format. If you are writing the format that I'm giving, that is also good enough. Okay. Now lease. This is basic stuff. What is lease? The theory part. Again, any kind of deed and agreement will have the same format. This deed made on so and so date at so and so place between so and so party, whereas party 1 has come and party 2 has agreed. Now these deed witnesses as follows. Okay, some clauses you learn, write it, and then you say in witness whereof the parties have set their hands on the date and terms mentioned below. So these are my essentials. In your module, all these essentials cannot be written because the module will become really vast. So cut some things, they cut short. Here they have not given the in witness whereof. That doesn't mean that you don't have to write. It has to be there in every agreement and deed. I hope I'm able. Then leave and license agreement we've covered. Let's go to something new. I'm just seeing whether we are covering. Then mortgage. Now again, mortgage deeds are also very, very important. It's one of their favorite questions because you just need to know the types of mortgage. And then accordingly you will twist the words in the agreement. Same format, absolutely nothing else. Okay. Okay. So then comes gift deed. Extremely important gift deed also. Format is same. You don't need to learn. Only one essential you need to know. A gift needs to be accepted. Okay. So that aspect will come. So if they have not given, doesn't mean that they are right. Okay. You need to know your legal essentials. Draft it perfectly. Then it is done. I'm going to things which I have not covered in the drafting. All this, if you see, is all attemptable perfectly. Then they have got some new kind of drafts that is there through amendment. That is ADR agreements, alternative dispute resolution agreements. Sir, what is ADR? Arbitration agreement, mediation agreement. You know, Mediation Act was passed recently. So, arbitration, mediation, they all will come. Now, what is this? One of the type is that we are referring the matter to one sole arbitrator. Now, sir, what do we do? Nothing. It is an agreement, na? So same thing you write. This agreement of this arbitration agreement made so and so between so and so party, same format, exactly same format and ended. So reference to a common arbitrator. So so each one has appointed one arbitrator, and that arbitrator is appointing another arbitrator. Format is something exactly same, nothing new. And obviously model mediation clause is the same thing. So if I talk about model, I mean there are no specific things. Let me tell you how do you draft an arbitration clause. I had shown you all yesterday. Okay, party shall, when you write an agreement, you write that the party shall endeavor. Now these are languages that you learn, you can fit. Endeavor to resolve the dispute amicably. Party shall endeavor. Now if I am making an arbitration clause, I'll mention the party shall endeavor to resolve the matter amicably, failing which the matter shall be referred to arbitration. Okay, and then you will say that the arbitration place where it will be, which act will apply, etc. This also mediation agreement they had added through an amendment. Okay, but the concept, any agreement format is same. This mediation agreement we entered in party 1, party 2, whereas they had come. So you can say that the parties had entered into a contract for which there has been a dispute with respect to the payment and the quality of goods. For this XYZ matter, the matter has been referred to and Mediator. The mediator, you should know, cannot pass a judgment. So you will write, we appoint the mediator. Mediation is a voluntary agreement reaching process. So let's see one mediation agreement. Confidentiality, cost of mediation, all this. So this is an agreement. Scope. So the scope of mediation shall be determined mutually by the let's see, confidentiality this and jurisdiction. So in witness whereof the parties have signed. So similar thing, just few essentials of mediation you can write. Okay. Now employment contracts, very easy and very when you're employing. So again, what is it? An employment. So we are employing a managing director. So how that agreement will be? Very simple. It is an agreement of service agreement, employment agreement, same format, nothing new. I don't think there's anything new that we should go. Settlement agreement, again, very important. Do you know how to settlement is there? So you have to see, format of agreement is same. You will mention one point, that there was a dispute for which we are settling and parties will not take it anything further. It is full and final. So you will write settlement of family. So basically what are they saying? That family, they have disputes that I want this property, that property. So all of them, they had one day come together and said, let's make a deed of family settlement. So this deed of family settlement made between XYZ party, party 1, party 2, whereas party 1 has approached, this you can write in your own words. So here they have written party 1 was doing this business, party 2 was doing this business, and they have mutually agreed below. Party 1 shall be entitled to the properties given under schedule 1, they will get schedule 2, etc. So just situational based, but the format is same. Remember, you have to write like this format, so it gives the effect and this of a legal draft. Clear? Let's see. Right? Can you explain the types of power of attorney, please? See, very simple. You want to understand the types of power of attorney. It's super simple. Okay, types of powers of attorney. So power of attorney. Now power of attorney could be of two kinds. One is a general power of attorney and the other one is a special or specific power of attorney. Is this what you are asking me? Yes or no? So a general power, so power of attorney is basically appointing a person to do a task on your behalf, on your. So for example, I am out of India, I will give a power of attorney to my brother to collect the rents of the property. So a general power of attorney is for more than one task, So maybe like to example, you give it to directors. Now directors on a day-to-day basis can take a general power of attorney. A special power of attorney has been asked in the exam, and same situational they are asking every time. Okay, so same thing they are asking, the special power of attorney, that is for appointing a CS to open bank account. So by this power of attorney, okay, know all men. So this I had explained in yesterday's lecture. Okay, so that is there. So this is just to do a specific task. Bylaws, just a theory. Then comes standing orders, is just very simple. That's it. I think it's done. Yeah. Now, very important. Yesterday only I was discussing, today actually, with respect to notices. Now, notice under Negotiable Instrument Act. Now, section 138 is about check bounce. Now, if you ever, I have handled check bound cases also. Okay, and I'll tell you, it is an extremely time bound act. So they will tell that within 1 month notice has to be given. Within next 45 days, reply should have been received. Or within this much time, you should have filed a case. If you not met the deadlines, you cannot file a case of check bounce. So again, I'll repeat. Now this is about section 138, which is not there in your portion. But I'm telling you, I'll explain one thing also, that in section 138, timelines are given, that within the, if I've given a check to someone, let's say someone has given me a check and it has bounced. Bounce means it has been dishonored. He didn't have money and he just fooled me and he gave me a check that take 30,000, take 5 lakhs, 6 lakhs, and it bounced. The moment it bounced, it is my duty to send him a legal notice within 1 month. If I don't send, I lose my rights under section 138. You know that? Everything is very strictly timed in practically a life. Okay, in your act you might not have, but courts have described the pattern. Now, the penalty and all that they've given you, see the conditions. Conditions for prosecution. Notice for dishonor. The payee shall demand notice to them within 1 month. If this you miss, you cannot go ahead with check bounce case. Imagine, check has been bounced, within 1 month you have to send them the demand or legal notice. And not only that, after I've sent, then the check must be presented to the bank within 6 months from the date it has been drawn, or within its validity period, whichever is earlier. So I also need to, within 6 months I need to go, must be presented to the bank that listen, it has been check bounced, give me a proper, or why it has been bounced, etc. That also needs to be done. So these are timelines which you don't need to learn, but they are sending about legal notice. And now we have to send a legal notice. So very, very important. Now I'm going to teach. So letter format, we did something today. Letter format. Done. I told you letterhead, date, then you start with to whom you are sending, then subject, full format I had shown you. Now we are going to do legal notice. Now legal, and also learning to reply to legal notice. Reply to legal notice. Very, very important. Concept clear? Yes or no? This is something new we will be doing. Now, first thing is, do you know how to draft a legal notice? Just let me know in the chat box, comment section, even if you're seeing later on. Let me know. Do you know how to draft a legal notice? And do you know how to reply to legal notices? So till now they haven't asked, but it is a high probability that they ask in your examination, because they might get bored of all the repeatedly asked drafts. They will say, let's ask something. It's there in your module. Okay. Okay. Great. So let me tell you. Do you know how to draft legal notice? Yes or no? In the chat box. How is the start, what is to be mentioned, how the end is there, what is the format. For every type that I'm teaching you, you need to have a dedicated format made. Okay, though I have given it, but you, when you write, you will be able to learn and you'll know how to present it. Okay. So Dalayandi, great. Now after this, you will know it perfectly. So a legal notice is also in, very good. A legal notice is also sent as a letter format only. So you will always have the same things. The legal notice will also have the same thing. Date, to whom you are sending, and then you come to the subject. Then you write the subject. And in the subject, so it is also letter format, but few essentials will be given. Now always remember, a legal notice is sent by a lawyer or a company secretary. It's not sent by the party. So always when I'm sending it, like for example, I'm sending a legal notice. So I am a lawyer for my client. So I will say, under the instructions of and on behalf of my client, I serve upon you this legal notice. In practical life, open any legal notice, this will be the language. Okay, so we'll say legal notice under section 138. Dear sir, dear sir, under the instruction of and on behalf of my client. So this is the language that you will start off with. Okay. Okay. On behalf of my client, son of etc., I hereby serve upon you this legal notice. I hereby serve upon you this legal notice. My client and you have been in a business relationship for so many years. Now, understand the structure of a legal notice. The legal notice will start with the facts chronologically. It will start with my facts chronologically. That how I have been introduced to you, for how many years we are doing business, and then we will start with the issue. Concept clear? Yes or no? So first I will say that my client, on behalf of my client, on instructions of my client, I serve this legal notice upon you. And my client, so always the legal notice is turned my client, my client, my client. So my client and you have been in business for so many years. Then I slowly start talking about the issue. Between specific dates or on 23rd October, you purchase the goods and my client has repeatedly asked you to make the payment in spite of receiving the goods. Then after 10 months when my client approached you, you made a payment of XYZ partial payments, and these are the check numbers in which you issued the check. At that time my client asked you about the remaining balance. You assured him that you will pay it in near future. So what are we doing? We are trying to explain that what happened. Following my client, they deposited the check and it was dishonored, but you failed to return the amount of rupees this much. Now we are coming after mentioning the facts, then you will write the ending. How do you end it? In light of the above, this legal notice, now you are ending it, that in light of the above, this legal notice is being issued under section 138. You are required to pay this, okay, within a span of 15 days of this notice. It is mandatory, okay, all these timelines are exact. Don't go and say 30 days. Law has given that within 1 month notice has to go, and in that you have to say within 15 days to pay you. If the payment is not made, you will be prosecuted. So then within how much time you have to go? 6 months you have to file a case also in the court. Within this. In event that these proceedings are initiated, you will be responsible for all the cost and consequences therefrom. A copy of this notice has been kept for necessary action and future notice. Yours sincerely, sincerely, your name and your advocate's name. Now, I taught you all a legal notice. Yes or no? Everyone, yes or no? How to write a legal notice? On instruction of my client, I serve this notice upon you. Now, very interestingly, how to reply to legal notice. Legal notice. And the principles are the same to reply to a plaint. When I am a plaint, I am replying, it is called as written statement. When in the court I receive a petition that someone is complaining, which we make, they have taught you very well, they have taught you how to draft petitions in court, but they have never taught you how to reply to petition. In your entire module, a written statement format is not given properly. Which is equally important, because what if I am on the receiving end? What if someone is serving my client a notice? What if someone has filed a case on my client? How to reply? That is a written statement. So there are few principles that, now pay attention to this. This is very, very important, because in my opinion, if I was drafting and I want to set a paper, very nice, tough one, I will ask them how draft a reply to the legal notice, or I will ask to draft a written statement. That is when I will come to know how many people really have understood drafting. So in that, very important, pay attention. How to reply to legal notices, or I could also say your petition or plaints. Okay, how to reply. So you have to understand one thing. Okay, you need to tell that every point of the plaint. So every point or para of notice that you received or plaint has to be reference has to be given to each point chronologically. So referring to your plaint para 1.1, referring to your legal notice point 2, referring to point number 3. So each one has to be replied. So each reply or each reply has to be in chronological order. Chronological order. Concept clear? Yes or no? Chronological order you need to reply. Second important. Each allegation has to be denied. Each allegation has to be denied individually. Because if you miss to deny each allegation, so obviously there is a science or there is a legal principle to reply to all this. In your module, they've never covered that much. Each one has to be individually rebutted, replied, denied, because if you don't, it is deemed acceptance. And third, you need to know your defenses, which one you are planning to take, which you will write after replying to each point. For example, you told me I did this. I said no, I did not do. You did this. No, I did not do. But that doesn't end. Now my targets will come. My attacks will come. Counter attack, counter claim, set off. All my defenses I should be aware. That the court did not have jurisdiction. That the limitation period is over. That I made the payment, etc. So when you read the pleadings, defenses has been given, traverse types of defenses, traverse, etc. All that has been given in the pleadings chapter. Clear till here? Have you understood? Yes or no? Let's start with the replies. Okay, Dave, great. Okay, difference between format to a legal notice and okay, very good, very good. I'll explain. I'll come to it. Okay, now in a format of reply. Now, what is the format of reply? Always it will be in the, it's very simple. You have to copy paste. It will be in the format of the notice or plaint. Means if I am replying to a legal notice, the format that he is given, I will follow the same format, denying everything individually. If I am replying to a plaint, then how he has written in the court name, party's name, everything, I will write the same thing. I will just copy paste the same thing in the same format. Just my pointers will be that we deny your point number 1, we deny your point number 2, we deny point number 3, we deny point number 4, and then I will start with my defenses. Concept clear? So format of a reply will be in the format of the complaint. Clear? Yes. So now let's start. Now since this I received a legal notice in a letter format, I will reply in letter format. So same thing, everything, date, to, subject, you'll just write the word reply to legal notice, dear sir. Now here you will say that, now see, it's very interestingly how each point will be rebutted. Okay, now this is another way of starting. You can even say that my client has served, but you can also, this is a different start, that I, the undersigned, and I'm writing this reply on behalf of my client regarding this in response to your legal notice. See, your start will be, I, the undersigned, who has signed here, I'm replying to this particular legal notice on behalf of my client, and I will give a very specific legal notice dated, or sometimes legal notice have a reference number in reference to legal notice XYZ. Then, and you always start off with this. Okay, and you always start off like this. Any legal reply of a legal notice, they start off extremely angrily, And before I start anything, let me tell you, everything is false, everything is frivolous, you have been, it's vexatious. So at before even starting to each one, I start in the very beginning. At the outset, I like to inform you that the allegations made in the plaint or in the legal notice are false and frivolous. The claims made by your clients are baseless and concocted. Therefore, I request you that your client withdraw this notice and issue an unconditional apology for making unfounded allegation against my client. So this first googly you throw it to them. At the outset, I like to inform you that all the allegations are false and frivolous. It is concocted, means it has been designed by your client, and it is completely baseless. And issue me an apology for unfounded allegations against my client. Now, this is language that you have to learn and write like this only, to let the examiner know that you have a certain substance. Now you see how it will be responded. Okay. Contrary to your claim, my client did not place the order. So here we have not written that way, but yeah, there it is. This is how you reply. So see the reply. See the reply how it is. Whether it is a plaint or any kind of legal notice. Para 1. The claims made by you in para 1 are denied. The contents are denied of lack of knowledge. This has been reiterated as stated above. Part 4 and 5. The contents of this have been denied due to lack of knowledge. No comments of this has been given, but it has been denied by my clients. So each para of the written statement or the legal notice has to be picked up and then replied. Did you know this? Did you ever know this? Not there in module. Not taught in module properly, but this is how you reply practically. Okay, so what you do is you take each point and say are incorrect and deny. We did not do this. Are denied. My client never issued this. My client never authorized you for this. So each para 1, para 2, para 3, para 4, para 5. So even that party will be like, I sent him 7 paras. Each para he has individually denied. That has to be done. And then you write that in conclusion of the above facts, I advise you to withdraw the notice and further advise your client from refrain from pursuing such frivolous case. Should your client continue, my client shall be restrained to contest the same and proceed against legal action against you. And my client reserves the right to seek cost, risk and consequences arising from this matter. A copy of this reply has been kept for my future reference. Clear till here? And that's it. The chapter is done. Then we go to chapter 5. Now I think I've completed almost everything. Okay, and I'm satisfied that now you will be able to attempt the entire drafting paper. See now LLP agreement. Very simple. It will just be up to in LLP they have that deed. Nothing new. Okay, profit sharing. Now this format is same. Nothing new to show you. I'm just seeing that if I'm missing out on anything. So by that time you all can also flip from your module any kind of drafts etc. Theory everybody can build. They lose marks in drafts. Joint venture agreement. Again very simple. Absolutely nothing. This joint venture agreement made between company 1 and company 2. Whereas company 1 was engaged in this business, company 2 was engaged in this business. And whereas both the parties, both the companies have decided to start a joint venture to do XYZ business. In now this deed witnesses as follows, mention it and close it. Okay, whatever it is there. I have told you standard clauses which come, which you can write. So you don't have to think every time what all to do. All that you will find on my website. Foreign collaboration. A moment foreign collaboration comes, automatically you have to remember RBI. Because if in a foreign collaboration agreement, I don't see foreign currency, I don't see the words RBI, I'll give a 0. That this guy doesn't know what he's doing. Right? So always they will say that royalty, right, for technology transfer, duration, rest all is the same. The format is exactly the same. Okay. Just going through anything, if I feel new, I will tell you. Same. An agreement is the same, agreement deed. So franchise agreement, it's the same, but you need to know it. The theory is important for this. What is a franchise? So this theory is important. It can come in your exam, okay? What is a dealer, distributor and franchise agreement from the theory point of view? Now with a dealer, you can have MRP, you can have non-compete, you can have restrictive to an area. Even in franchise agreement, you can have non-compete, etc. Okay, these are all important that they can ask you. We are done with this, nothing new. NDA, non-disclosure agreement. Again, I feel very, very important. Normally, companies have a clause only, but a non-disclosure agreement could be there separately entered. Can anyone tell me? Can anyone tell me when a NDA is signed? Chalo, let me check your knowledge, legal knowledge. When is a NDA, non-disclosure agreement entered? Difference between the format of reply and written statement. Difference between the format. So I have told you, will that be given in the question? Yes, in the exam question they will tell you draft a legal notice, then you draft it in the legal notice will always be in the form of letter. If they tell you reply to the plaint, if they tell you reply to the plaint, so when it is in the court already, then you have the written statement format. So in court, you have the written court format, and when it's just at initial stages. So normally what happens is first legal notices are exchanged. So that court is not involved only. It is only when the court is involved, then I have a court format. So I'm asking you all, when is the NDA entered? Quickly, I want you all to type scenario. I hope you all have this basic knowledge. The very, very basic stuff you should be knowing. When is a NDA entered? Right, I want you to type. So if you remember, okay, if you remember, even in you have your due diligence subject also. When you go to see this, whenever there is a due diligence happening, due diligence, okay. Now why a due diligence is happening? Because there is a seller company, and there is a very good. Save your right when merger or any transaction. So seller and you have a buyer company. Now pay attention. What happens is if they want to buy specific confidentiality agreement, that time why will you have NDA? I mean nobody why I'm asking why would you have a confidentiality agreement? Sudha, I'm asking why will you have a confidentiality agreement? So there has to be some transaction going on, right? So let's say a takeover or a merger or I don't know whether you know it, slum sale. Have you heard of the word slum sale? Slum sale, okay, merger, takeover, etc. So these are transactions under which NDA can be entered, non-disclosure agreement. Now pay attention when and what stage it will come. So first is the seller company and the other one is a buyer company. So I want to sell my company. But before that, the buyer will say, I want to do some due diligence. What do I want to do? Some due diligence on checks. Background checks I need to do. Obviously, I've done the background check, but now I need to check details, which would normally not be available in public domain. I will check certain IPR documents. I will check everything. Okay. So the seller company has to transfer info. So they have to give confidential info, okay, to the buyer company even before selling to make the sale happen, right? You have to share. So then they will analyze all the information. So this process is called as due diligence. Now while doing due diligence, they will tell that listen, we will hire a agency, okay, maybe could be a firm, a law firm, a CS firm, etc. A firm will come to do the due diligence, right? Now they will say that listen, yaar, we are sharing all confidential information not only with you but also with this firm. So I want you all to enter into a non-disclosure agreement that confidential information, correspondence, documents will be shared in this process for takeover, for slum sale. Because then you will say that they will not share it to anyone. You have to show a letter of intent is first signed. Letter of intent, that I intend to buy your company. So buyer will send a letter of intent first. I intend to buy your company. I want to do a due diligence. Then we will share the information. Before sharing the information, we'll have a NDA agreement. Concept perfectly clear, yes or no? So now always in a NDA you have to mention a transaction, that why are you entering and why is one party giving confidential information to the other one, right? So now let's start. So it happens in a transaction. It happens in a transaction. Okay. Now, non-disclosure agreement. So this NDA agreement now it's an agreement, right? So between party 1, party 2. Now see, whereas party 1 wish to negotiate a potential business arrangement. So there is a potential proposed transaction. Parties acknowledge that these transactions are confidential and proprietary. That the parties acknowledge that this information is, secretive, confidential, proprietary. The parties agree to maintain confidentiality to safeguard their prospective and business interests. Now these witnesses follows. The confidential information shall be with respect to whatever, shall not be limited to trade secrets. The receiving party shall not disclose it to anyone. And after the transaction is over, they will destroy the documents. So each party shall protect the information in the same manner it protects their own confidential data. They will return upon termination of the discussion. Within 7 days, they will destroy all the copies. Limited. They can only share limited information on need to know basis. Okay. Exclusion. Confidential shall not include any public data. So they are defining that if it is publicly available, it's not confidential. Right. And then you will indemnity. In case if anything goes wrong, then indemnity needs to be given. And then arbitration clause and in witness thereof. Have you understood? NDA agreement is also very, very important. They're not asked, but almost it's different, so it will be there. E-contracts is theoretical. E-contracts, this they ask in the exam. Okay, this the theory part they ask in the exam. Very simple, very basic. Okay, very simple, very basic. So they ask this in the exam. Okay, so these are past exam questions. Any of them they can ask you. It's a theoretical thing. Then moving forward, I believe I've covered everything. Okay, now just one thing is I want to take you through is a legal opinion. Now pay attention to legal opinion. The art of drafting legal opinion. All I have covered, every single thing that is there is covered. Okay, now only one last format I need to show you is what they have not asked in the exam. They have never asked a legal opinion in the exam, but I will give you the format because as a professional, I see in the firm we give legal opinion. So while giving legal opinion, there is a certain format that we follow. Okay, because when you will start your own firm or you will work in a law firm, clients will come to you with complicated questions. Now, how do you reply to that? So that you will have to give your opinion. They've given you the theory of art of opinion writing, but they never given the format only on how the format is to be given, which is really needed. So if I go to see that what is a legal opinion? A legal opinion is a professional opinion, a written subject on a important aspect. Okay. They give you what is a legal opinion, what is a sound legal opinion looks like. So I'll just give you the format. I'll show you one few format that we have used. Now see. Now see, this is a legal opinion which I had drafted. Okay. Now this is always you write introduction. Now pay attention to this. If they ask a legal opinion, so this was about a company. Okay, this was about a company. I've changed the name. they were into online gaming, okay, and they wanted to know the legal position, whether it is allowed or no. And a beautiful gaming, so these young people who were into technology, they made a game, and this game they wanted our opinion. You want to know what is a game and what is the question? Yes or no? So I'm teaching you a thing which is not there in your exam book at all. Very unlikely that they will ask you, but I feel it is important from practical life perspective. So the legal opinion format. Legal opinion format. Do you all want to know it? Yes or no? Or should I skip it? Do you want to know or should I skip it? It's never ever asked. I don't think they can ask you in the exam because not format is only not given. Do you want to know the format? Yes or no? Quickly, it will just take 5-10 minutes. Do you want to know yes or no in the chat box? So I will tell you. Yes, there is a recent law also that they made on online gaming. So let me tell you what was the game about, okay, and what was the question. Then I will tell you the facts. So this guy, like how you have online games. Now this guy asked us a question that we will take the NSC data. You know, NSC live data is there. It is available on NSC site. From that, they will allow, betting on that. See, betting is also in India, it is allowed, okay. So they wanted to take, now how betting used to happen occasionally, like there is a cricket match, Dream 11, etc. Now obviously government is trying to kill all this, but what this question was, they wanted to pull the NSC data, and instead of buying Reliance, you can only bet on Reliance whether it will increase or decrease. So you are not buying share of Reliance, you are not selling share of Reliance. Only on that data they take, and they have betting and games on it. Games. So whether you won, so for example, I say this will go up. Now the price points will be very less. So you don't really have to buy Reliance and win that. So you can have betting whether this will go up, that will go up. For example, this IPO will succeed, that IPO will succeed, it will go up. So a game will be made on it and betting will be done. And this is completely different. So we will win a bet or lose a bet. So now the question, legal opinion they ask is, can we pull, live data is already available, can they use it into an app, the data of NSC live data, and use it to make online games? So first we had to explain. Now if someone will ask you this question, the job is first to tell an introduction about the company, what is the company about, then give them a proper understanding what it is, then give them the legal position. So then I had to tell them that legal position, okay, legal position with the case laws, what it is there. We have to research case laws. We have to see that nobody can stop you under Article 19(1)(g) in Punjab, and Haryana court has also said, and under betting and gambling is coming under 7th schedule of the Constitution of India. So deep study goes into that, okay. Then comes ban on online gaming. Many states have banned online gaming. Telangana was the first state to ban online gaming in 2017, then Andhra Pradesh. So the owners wanted to know from us. So Kerala High Court has struck down the law saying that it is unconstitutional to ban a blanket ban. It violates Article 19(1)(g) and 14. Okay. So Tamil Nadu has passed a Tamil Nadu Gaming Police Laws Amendment and struck down the Madras High Court. Niti Aayog. Now this, they had told correctly that a particular law has come. So online fantasy sports performance in India particular, this has come. The sports, online gaming and prevention of fraud. So all this we have to give the legal things which goes into, you can see the immense amount of depth that we go in each one. Information technology, intermediary and digitally media ethics code. Then which ministry will come. So all of that we have to give and then give our opinion. Indian scenario, etc. So, and then we've also given that certain companies which are there, similar lines. So this is a deep research, but now let's come to the format and close it. Okay. So a format, how it is there. Now pay attention. So first you write. Now you can just take the format that memorandum of opinion to whichever company who you are sending it to from. Then you will tell what is the subject regarding what date. Then you have to give a background that this was a company, like about the company, it's a private company dealing in XYZ. What questions? So questions asked, and then each one you have to answer along with the law. Okay, so this is normally written as private and confidential for internal purpose. I've changed the names. Okay, then this was an old matter which was there, and in the end you give your opinion and you end it. Okay. Similarly, if I show you another opinion, so again coming the ending part, you have to give the introduction. Then so now you can write it down. Okay, what will you do? You'll write the introduction where you give the background of the company or background you can write. Then you'll write an advice and opinion required with regards to all the necessary measures that should be taken. This is given, and in the end you will give your legal opinion. Let's see an easier draft if I have. So that's it. I think just a simple little format is sufficient. Clear? So I don't think they can ask you that, but just important from knowing, I think you should also have your own format just in case they ask in the exam. So with this, I conclude my entire marathon, where you will see that any draft from the module now you pick up, you will be well competent to write it in your exams, and I guarantee you the exam drafts will come from what I have told only. Okay, so this you will check because I've covered almost all the drafts of drafting. Okay, so that is it, guys, for today. I have covered the entire drafting marathon. Now, sir, what about theory? How will we do that? So I will be launching the dream batch in a few days. Right now I've launched the test series. The test papers will start being uploaded, so you can start writing, and the dream batch will give you access to all the paid lectures at a really nominal price. So that is also going to come in the coming few days. So join the WhatsApp group, like the video, it doesn't cost you anything, and third, please share it with your friends, let others also know about the classes, because you will see very few faculties classes give this kind of service, or you could say give this kind of efforts, commitment to their students. It feels happy that I can reach out to all of you all. I keep it in English especially so that students from all over India, including our South India students, can learn, and they should not be struggling and having a language barrier in learning. So if you're from South India, please share it with your friend circle as well. Our classes in Mumbai are in Andheri, so please do visit, meet me. I will be happy to guide you as well. Wish you all the very best for your examinations. Do really well. Everything has been given. I've given you all the scanners where the past exam questions are there. I've given you all a marathon, gives you a brush up into the insights. Third, I'm giving you the test series, and fourth and most important, I'll be coming out with the access to the paid lectures also. Thank you so much, Dev, for your kind words and being so present. All of you all for being, throughout the entire lecture, having a desire to learn and trusting that I'll be able to deliver to help you do better. Take care, guys. Thank you so much. Have a great day. Please share it with your friends. Inform them as well. Thanks, Dev. Thank you, everyone.